Welcome to my channel, All for Health with Jane. Family, we are on the AKA and Tibz murder case. On this video, our focus will be on accused number 2 only. He is being represented by Advocate Vol Marans. Accused number 2 was arrested in Johannesburg, Maponya Mall, and he was arrested for another case and was sent back to Durban for that case. And when he was in custody, he was informed about the AKA and Tibz murder case. So today he's here in court for the AKA and Tibz murder case, applying for his bail. So we are going to listen to Advocate Vol Marans as he is presenting to this court the reasons why he feels and believes very strongly that accused number 2 deserves to get a bail. Let's listen.
Let's place on record that applicant 2's heads of argument are accepted. I have got a hard copy thereof. And it's accepted into the record. It's marked Exhibit O.
Yes.
Thank you. You may proceed.
Thank you, Your Worship. Your Worship, as I've said, I associate myself with what my learned friend for accused 1 and 5 has said with regard to the various authorities that he has referred to. Your Worship referred to, in a question to my learned friend about the delays. What must be borne in mind is that applicant number 2 has been in custody since October last year.
Sorry, Counsel. Clarify yourself. Delays? What delays are we talking about?
Sorry.
What delays are we talking about? Let me
The
understand.
delays that Your Worship, well, it was first raised by my learned friend for accused number 1, and then you asked him about the delays. And I'm just saying, this bail application started in March.
Yes.
He's been in custody since October last year. And it's not as though he was unaware of this particular case. He was aware of it. And he was questioned about it at that time when he was arrested. So this is nothing new to him. And when he handed himself over through his attorney, then where does the flight risk come in?
Applicant 2.
Sorry, Your Worship.
Applicant 2 hand himself over.
Yes. Sorry, Your Worship. He was arrested in Johannesburg.
Yes.
My apologies.
Yes.
But he's been aware of this case all along. That's the point.
But he was in custody on another case.
Yes. But he would have handed himself over had he been given the opportunity to do so.
But Mr. Volmarans, let's understand each other so that we will flow. Where does handing himself over come in when he was arrested in Maponya Mall and brought to KZN?
Your Worship, it doesn't come into it. What I'm saying is, if he was out on bail or out at the time that his co-accused, he would himself, because he's represented by the same attorney, had he been out and not in custody, he would have handed himself.
I think let's rather talk about what happened. Let's rather talk about what happened.
Yes.
Did he hand himself over? Was he arrested?
He was arrested in Johannesburg.
So handing himself over does not feature.
It doesn't enter, as Your Worship points out. Now, as has repeatedly been pointed out by my learned friend, the state has not taken the court into its confidence. And Your Worship raised the question about the investigation and how far it was and so on. And if I may quote from the state's heads of argument, which unfortunately you have not had the opportunity to read, but if you go to paragraph 62. The state further indicated on Exhibit G that there are further investigations that are still outstanding in this matter. It has been indicated that there is all likelihood that further persons may be added as accused in this matter pending the finalization of investigation. It is not a secret that certain evidence is being followed up, which means that the investigation is not complete. There can be no other interpretation to that. Therefore, to indicate that certain people should have been arrested at present is jumping the gun. The state never mentioned that the door of investigation has been totally closed. The contrary is actually true. So the state are conceding that the investigation is nowhere near complete, which means there is going to be delays. All right? There's been a delay since February last year when the deceased was shot. The extradition proceedings, and if there is a person who can talk with authority, it is my learned friend for accused number 1 and 5, because when he was part of the DPP's office, that was his function, was to deal with extraditions. And, Your Worship, I have no doubt that he is not going to contradict me if I say an extradition from one country to another, as close as what we are, can take up to 2 years, if not longer. So we're not looking at a trial which is likely to take place any time this year. Your Worship, I'm not going to deal with the bank statements, even though I handed in accused number 4's affidavit. My learned friend for accused number 4, applicant number 4, will deal with the bank statements. But there's a lot to be said about that. Your Worship, it is not sufficient in a bail application to say that there is a risk unless that risk is backed up by evidence. In other words, the authorities have said that there must be a likelihood that a particular result is going to result because there is evidence to support that. Bail should not be refused merely because the police say there is a risk. Now, as far as accused number or applicant number 2 is concerned, there is no evidence to suggest that he is a flight risk. The mere, if I can use an example, if the state were able to produce an aeroplane ticket that was imminently to be used, then the state has reason to be concerned that he's going to be a flight risk. But merely to say he's a flight risk is not sufficient. Your Worship, the state has seen, and I can find nothing else in the state's heads of argument except which appears at paragraph 63 and 64, where the state deals specifically with applicant number 2. And it's on page 60.
Yes, I've got it.
Yeah.
Paragraph 63.
Now,
Dealing with the passport.
yes, dealing with the passport. Applicant 2 knowingly supplied false information in another bail application that he was not in possession of a passport. Now, if one goes to Exhibit L, at paragraph 3.5,
Yes.
he explains that. The position is, Your Worship, that when the accused was arrested, his passport was seized. It's not as though the police had to go look for it. They were in possession of it. Up until today, they are still in possession of it. So to make a big song and dance about him allegedly lying when he says, look, it's a genuine mistake. The drafter of my affidavit made a mistake. I didn't pick it up. Can't hold that against him. And what is more, Your Worship,
The drafter coming to confirm that I made a mistake. Me, Miss or Mr. Drafter made a mistake.
Your Worship, it's not required. He doesn't have to prove every single thing that he says. The state are aware of it. So what difference is it going to make if the drafter, who happens to be me, says, I made a mistake? Where's that going to take the court? It's not going to take the court anywhere.
But these are bold allegations made by the state that he
Precisely that, Your Worship.
lied. And the response by the applicant is that it is Mr. Volmarans who made a mistake, the drafter. The state is aware, but is the court aware?
Well, that's what I'm saying, Your Worship. The court is now aware because he's put an affidavit up to say it. It was a mistake. It wasn't deliberately done. It was never deliberately done. But in any event, Your Worship, I submit that the state was wrong in putting up that affidavit, in fact, putting up those, that bail application. All right? And the reason why I say that, I've dealt with it extensively in my head, Your Worship, but as well, if you read section 60, where it deals with the record of bail proceedings, and I'm quoting now from the Act, the record of bail proceedings, excluding the information in paragraph A, which is for previous convictions and pending cases, shall form part of the record of the trial of the accused, following upon such bail proceedings. It does not say any proceedings. So those bail is not criminal proceedings. So the state were not entitled to use that because it is only admissible at trial, not any other time. And, Your Worship, as I say, I've dealt with it extensively in my heads. Now, paragraph 62, or rather 63 and 64 of the state's heads of argument are the only thing that they can point their fingers at the accused as having, let's say, done something wrong. He hasn't done anything wrong. It does not say subsequent proceedings. It just says trial proceedings. So they were wrong in using it.
But could it not have been misleading to someone who is not informed?
Sorry, Your Worship, I don't
Could
know.
it not be misleading to someone who is not informed, like the state, which is informed that the accused has a passport because it was seized upon arrest, to someone like me who does not have such information, could that not be misleading?
Your Worship, not when it's explained.
So it is until it is explained.
Yes, it's been explained. In Exhibit G, they make this allegation. In Exhibit L, it's explained. The state have been aware of it all the time. They can't say we were not aware of the fact that the accused had a passport. They can't say that. They were aware of it. They were in possession of it. So, Your Worship, that statement was not designed to try and mislead the court. That's why there's an explanation. Drafter of my affidavit made a mistake. What more would the person listening to the affidavit expect? Your Worship, other than the submissions already made, unless Your Worship has particular questions, those are my submissions, that the accused or the applicant has discharged the onus. He has his personal circumstances, the fact that he's been in custody all this time, the fact that he is productively employed, that he contributes to the fiscus, that he has a family to maintain, I submit are all relevant, and when put into the melting pot for the court to decide whether or not those amount to exceptional circumstances, I submit they do. There are exceptional circumstances. He has more than one wife. He has a number of children that he has to maintain. So, Your Worship, by keeping him in custody, all we're doing is making his children suffer. And, Your Worship, one must bear in mind the business that he is involved in, namely the taxi business. That's cash business. You can't collect his income. And that income, those people who are employed by the applicant are not going to go to his wife and say, your husband is in custody, so here the day is taken. It doesn't work like that. So his family are suffering as a result of him being in custody. And I submit that is a very serious consideration when it comes to both. Unless Your Worship has...
Well, we have touched upon it, and I want to take you back to it. His business is in the taxi industry.
Yes.
By his own statement under oath, his family is involved in Malugazi faction. Yes. And some of his family members have been killed. Yes. Through the violence that is there, because that industry is volatile, particularly at Malugazi.
Yes, sir.
The risk that is there, if he goes out, that he may also be eliminated.
Your Worship, as you've said, he wasn't arrested at Malagasy. He was arrested in Johannesburg. So he's kind of divorced himself away from where the violence is. He's still running his business, but he's not living in Malagasy where violence is taking place. He feels he is safe, because otherwise he wouldn't be bringing this bail application. He'd probably say, well, I'd be safer in custody.
But objectively speaking, is he safe?
Objectively speaking, yes, because the other members of his family may have been eliminated. Other taxi bosses this is something that happens every day, not just here in KZN,
Yes.
in all the provinces.
Yes.
But it doesn't mean that his life is under threat.
Is it
His
not?
life hasn't been threatened so far. As far as we know, we have no instructions to the contrary that his life has been threatened. So until there is a threat, an actual threat, not a speculation, then it's neither here nor there. Your Worship, I'm also advised that there has been government intervention as far as the taxi violence in KZN is concerned, which has resulted in a great decline of taxi violence in the KZN. I can't give Your Worship percentages, but so obviously the state are doing something right.
I'm raising this because it's contained in his own statement that the situation is volatile, and he cites particularly Maluga's rank, that there is that faction over who is to manage Maluga's rank. It's in his own statement. That's why I'm taking it.
I agree with Your Worship that that's what is contained in the statement, but he's not there. And he's not part of the faction that is trying to fight for who is responsible or who takes over the taxi rate. He has people working for him. And in any event, Your Worship, as was stated in his affidavit, any right, I'm loath to use the word likelihood because the state uses the word interchangeably with likelihood and possibility. But any such likelihood, and one has just to refer to the Eastern Cape case, any likelihood can be overcome by the imposition of conditions. So if the court said, right, I'm releasing you on bail, but you may not go back to Malagasy. If he then goes back there, he's broken the bail condition, he can be arrested. All the state has to do is apply for a warrant for his arrest and he gets arrested.
I think let's do justice to applicant number 2. Let's be fair to him. Let's give him a hearing. Allegations have been made by the state that applicant number 2 is part of the group. He received 133,000 rand from applicant number 4. Don't you want to address the court on that?
Well, Your Worship, yes, he did receive a sum of money for services rendered. That's what he says.
But that's exactly what I'm saying. Don't you want to address the court on that so that it is on record that you have touched on that as well? That's why I'm saying let's do justice to him.
Well, Your Worship, I believe we have touched on it. We've said the money we received is for services rendered. What more do we have to say, Your Worship?
No, it's not for me to answer. I was just bringing to your attention that
Yes,
are you
Your
not
Worship, and
omitting,
that's
are you
it.
not omitting that one aspect?
No,
Because it's allegations
don't-
made against him.
I don't believe so, Your Worship,
Okay.
because I believe that by saying I received money for services rendered, he denies that he was involved in any nefarious activities of murdering the deceased and his compatriot. He denies that. He says, I will plead not guilty.
You see, I'm raising this so that there are no aspects of evidence that are left not addressed. That's why I'm raising this up.
Well, Your Worship, the services rendered are also explained by applicant 4. He says, yes, I received money. I distributed certain monies for services rendered. What more must he say? I'm sorry, Your Worship, I'm not questioning the court, but I'm saying.
But exactly, it's not for me to answer those questions.
No,
it's for him to say there is this piece of evidence that has been tendered, and there is that piece of evidence that has been tendered, and that piece of evidence, my explanation is grant me bail because of my explanation.
Your Worship, and I believe that I've addressed that. Grant me bail because, yes, I received money, but it was for services rendered, not for any unlawful purpose. Unless there are any other issues, Your Worship, those are my submissions.
Well, I've drawn your attention to certain aspects. I cannot draw your attention to all the aspects. As I was saying, let's do justice to each and every one of the 5 applicants so that we give them a fair hearing, that whatever has been said on their behalf is answered and is addressed. If you are satisfied as his counsel that you have addressed everything, I'm not going to poke you and say that. Wait
Your Worship, I do believe that the relevant issues have been addressed in my heads of argument and also properly answered in the affidavits. So if there's some aspect of my heads of argument which Your Worship is unhappy about, I'm happy to address that.
It's not that I'm not happy about.
Well, Your Worship, I use the word loosely.
Mine is to address my conscience and make sure that at the end of the day I've been presented with all facts and all facts have been properly addressed. Not because I'm not happy about anything, but
Worship,
I want to do justice to everyone.
Your Worship, I use the word unhappy loosely. I'm not saying you are unhappy. I'm saying if Your Worship has concerns, I'm happy to answer those concerns.
Anything else, Council?
Those are my submissions. Thank you.
Family, from the presentation or maybe the arguments by Advocate Volmarans, do you think accused number 2 deserves a bail? Let's talk about that in the comment section. Give reasons why. Do you feel he has to get it or not? Family, thank you so much for watching this video. Thank you for your support. Please like this video before you leave. Subscribe for my channel if you haven't done so yet. Thank you, family. I love you so much. Bye.